The Idaho Supreme Court slams the door on accused murderer Bryan Kohberger's attempt to get the indictment against him thrown out. We have all of the details. Welcome to Crime Fix. I'm Angenette Levy. This was Bryan Kohberger's last-ditch effort to get the case against him thrown out for the murders of Maddie Mogen, Kaylee Gonsalves, Xana Kernodle, and Ethan Chapin. Kohberger went to the Idaho Supreme Court and asked the court to basically take his case and hear him out. Kohberger argued a number of things, including that the grand jury was given the wrong standard of proof. Grand juries look at whether there's probable cause that a person committed a crime. That's the lowest legal standard. Kohberger's lawyers had argued that the grand jury should have been told to consider beyond a reasonable doubt. That's the highest possible legal standard and the standard used at trial. They did that because of some archaic language in the Idaho state constitution, but it didn't fly. Judge John Judge called it a creative argument and denied the request. And the Idaho Supreme Court said, we're not even going to hear what you're asking us. We're not even going to take it. I think I had actually called this a creative argument when they first made it, and it wasn't going to go anywhere. Jonna Spilbor is a criminal defense attorney and also a host here at Law&Crime. Jonna, are you surprised at all by this ruling by the Supreme Court? They didn't even take the case. They said, you know what? We're not even going to listen to this.
Not even a little bit surprised. I mean, look, this was a long shot to begin with, but it's not uncommon for these higher courts to say, we're going to leave the lower court's ruling alone, especially in a case like this, where personally, I think the defense was asking for something very lofty in the sense that they wanted a different standard applied to this particular defendant in his indictment. And, that requires basically an act of the, state legislature, not of the Supreme Court. So of the state. I'm not surprised at all that they said, no, we're not even going to hear it. You go on back to where you came from.
Yeah, I'm always kind of amused. And when I say that, it's not a ha-ha type of thing. But whenever I see these motions to dismiss indictments, I'm kind of like, it's very creative because I've never seen a judge toss an indictment. I mean, typically it just goes through the process and they say, this is for a jury to decide. A grand jury, it's the lowest standard of proof, probable cause. It goes through the process. It goes to trial, or you resolve the case otherwise through some type of plea agreement. This one was interesting. And I thought that it was a creative argument because they said, look, the Idaho Constitution that was written, 100 million years ago or whatever, a couple hundred years ago, says the standard of proof should be beyond a reasonable doubt. But since then, we've had, all of these rulings throughout other courts, and really the legal standard, and everybody knows it, is probable cause. And so they wanted the Idaho Supreme Court, this archaic language, they wanted them to consider the Idaho Constitution rather than what everybody's been using for like 60 years. So I don't know. I mean, does that really make a good appellate record when you're just kind of throwing out this argument that it's not going to fly? I'm sorry. They had to have known it was not going to fly.
Well, it was a novel argument. And, oftentimes defense attorneys do have to think outside the box. And yes, sometimes we do things because we are creating a record for the appeal that we know is going to follow. And in a death penalty case, if he's convicted of anything, if Kohberger's convicted of anything, we know there's going to be an appeal. So they could have been pandering to the appellate court. But look, I don't blame them for thinking outside the box. Could you imagine the avalanche of other cases that would have come if this court said, you know what, I think you're right. I think the standard's been wrong all these years. I'll give it to you. Goodbye. All these other cases that have applied the same probable cause standard at that level, at the indictment level, you wouldn't be able to handle them all. So we knew. I think as watchers, we knew it wasn't going to fly.
Yeah, we definitely knew. And even Judge, it's funny. He called it creative. And I think, Jesse Weber and I were on TV calling it creative even before Judge did as well. So, I gave them an A for effort. That's for sure. Yeah. The world can be a scary, scary place. This case makes that very clear. And you can't be too careful when it comes to being safe. That's why you can use truthfinder.com as a tool to keep you and your family safe. Truthfinder is one of the largest public records search services in the world. The goal is to help people like you learn the truth about the people in your lives. Truthfinder background checks anyone you search to look for any possible red flags. It will show you things like someone's past and current addresses, criminal records, even sex offender status. Here's how it works. Log on to truthfinder.com and, for example, put in your own name or put in the names of the parents of your kids' friends. Results will appear within seconds, telling you everything that Truthfinder knows about the person that you search. If you'd like to check out Truthfinder, and I think you should, you can get 50% off of confidential background reports. Just log on to www.truthfinder.com/LCCrimeFix and start accessing information about almost anyone. One thing, Jonna, that had the Idaho Supreme Court taken this, had they even said, yeah, we'll hear it, because they basically said they didn't even deny, I think we need to be clear. They didn't deny the appeal. They said, we're not even going to listen to your appeal. We're not even going to take it. So I think that we need to be really clear on what happened here.
That's true.
But this would have bought the defense some time. And the defense has continually said, we're not going to be ready. We're not going to be ready. I don't even think we can be ready by June of 2025 to try this case. Had the Idaho Supreme Court taken the case, this would have stayed the case. This would have stayed the proceedings at the trial court level. So this could have bought the defense possibly many, many, many more months before trial, possibly, and stayed the entire case. And they would have had even more time for this case to get possibly stale, for maybe a witness or two to not be available, what have you.
Well, you raise a couple of good points, because with my criminal defense hat on, I keep saying to myself, what is the big deal if the defendant wants to drag this out a little longer? And I only say that because there are some novel concepts that are part and parcel of this defense. First and foremost, this genetic genealogy, which I'm sure the defense is going to argue is junk science. And without that, Angenette, if somehow they get that evidence either thrown out or discounted, I mean, I hate to say this, it could be game over for the prosecution, because that is the thing. That genetic genealogy is the reason, the main reason. I know there are others. I know there are cell phone towers. But in terms of forensic DNA evidence, that is the thing that connects Kohberger to the crime scene. And it barely does that at this point. And I only say barely because we know that there was DNA on the sheath of the knife. So we're not talking about a ton of blood evidence where you would think there would be a ton of blood evidence or other DNA transfer evidence or what have you. So if the defense wants to take a long time and go through all that discovery and go through the science and get their experts, and he's behind bars this whole time, it is the defendant's right to a public and speedy trial. And if he's willing to waive it, why shouldn't the rest of us?
Right. And I think it's interesting you bring that up because I keep saying they had nothing until they got that investigative genetic genealogy identification. I mean, they had the male profile, the single source male profile, but they didn't have a name or a face to go with it. And they were able to get that through the genetic genealogy. Yes, they had the Hyundai Elantra, they had the white Elantra on camera. They had this, but that genetic genealogy is what led them to his parents' doorstep in Pennsylvania. That is what made it all come together in December. I want to say it was happening around December 20th. They may have had these pieces floating around in the investigation, but they didn't have that name connected to that DNA profile until probably 9 days or so, maybe even 8 days before they arrested him in Pennsylvania. So, Jonna, as a lawyer, could they say, yeah, you might have had the DNA. You may have had it, but you didn't have the name to go with it. And if you screwed up that genetic genealogy, if that wasn't sound the way you figured that out, could that get thrown out and the whole thing collapses?
Yes, it could get thrown out. Will the whole case collapse if that gets thrown out? Is there enough other evidence there that can't rely on that? It can't be fruit of the poisonous tree, right? Is there enough there to continue with the prosecution and successfully. Well, let's put it this way. Right now, we don't know. Maybe there's some information in the discovery that hasn't been made public yet.
Sure.
But based on what we know publicly, I would bet my money on the fact that if that DNA goes away, so does this case, unless there's more that we just haven't heard about yet. And that's possible, but we don't know.
Yeah. And I mean, it could be one of these things where they say, well, let's say there was an issue with we're speaking hypothetically now.
Mm-hmm.
What if there was an issue with the genetic genealogy and how that came to be? And we don't know that there was. We're just speaking hypothetically and speculating,
Mm-hmm.
of course. They may say, they would have eventually gotten there. So it may not matter. We just don't know. Jonna, this case, there's going to be a change of venue motion argued and heard on May 14th, rather, pardon me. Do you still see it going to trial? Judge wants this thing going to trial. Like, he wants it this year. It's not happening. More than likely, it's going to happen next summer, 2025. I just don't think that that's that slow. I've seen other cases that are big cases.
Right.
I know for the families, it's horrible and it's painful, and I feel for them. But this is a big case. I mean, it's a big case with a lot going on, a lot of discovery to wade through. Do you think it does indeed go in June of 2025?
I won't be surprised if it doesn't, because I do think the main issue is going to be this testing and this science, and whether it's junk science or not junk science. And you're right. A lot of other cases that are not death penalty cases, but are murder cases, take years and years to get to trial for a variety of reasons. And typically with the defendant locked up, let's stand in his shoes for a minute. I know that's hard for us to do, right? But if you have a guy who says, I did not do this, I wasn't there, I didn't know them, I didn't do this. And you have an attorney who's sitting you down and says, okay, listen, this is going to take us a really long time, years, to be able to prove that you didn't do it. And the entire time that we're taking to prove you innocent, even though that's not what we're supposed to have to do, you're going to sit in the clink with 3 hots and a cot. And it could be 5 years, 6 years, but you're an innocent guy. Are you going to be okay with that? He's got to say, okay, do what you got to do. Right? As opposed to, because one of the other things I thought of very early on, sometimes when you're representing somebody and there's not a whole lot of evidence, or the evidence is unreliable, you want to rush it to trial. Because if the DA can't get their hands on the evidence it's going to take to prove, you might be able to win because they weren't able to prove their case beyond a reasonable doubt. This could have gone that way, but quickly we ascertained that no, the defense attorneys in this case are going to go exactly the opposite. Comb through this evidence with a fine-tooth comb and see what can be thrown out in order for the prosecution not to be successful.
It's a lot. It's a big case. It's a lot. Jonna Spilbor, thanks as always. We appreciate it.
Always happy to be with you. Thanks, Angenette.
And that's it for this episode of Crime Fix. I'm Angenette Levy. Thanks so much for being with us. We'll see you back here next time. Until then, have a great night.